Thank you very much, and thank you, Dominic and Peter, for having me here. So I will first start with a few general remarks, continuing what we've heard in the first part of this morning, saying that the political ideas and ideals found in the Bible, in the Hebrew Bible, have a lot to do with Israel's experience of empires. And as numerous biblical scholars have emphasized, including several people here, various narrative, prophetic, poetic, and legal texts can be read as responses to Neo-Assyrian, Neo-Babylonian, or Persian imperial ideology and policies. And probably in part because of this underlying dialogue with empires, many biblical texts tend to be critical toward kingship. Ideally, the people of Israel should live under God's sovereignty and God's law. Now, post-biblical Judaism further developed this trend of thought. For example, the Temple Scroll from Qumran and other Dead Sea Scrolls, as well as Rabbinic texts, reflect about the ways royal power should be exercised and controlled, either by priests or by an assembly like the Sanhedrin. In my talk today, I would like to deal with another aspect of the political or political-religious legacy of the Bible in Jewish thought, and more precisely in Rabbinic Judaism. With Rabbinic literature, we encounter yet another imperial context, which we have just seen with Paul, that of the Roman Empire. Now, one of the striking aspects of Roman imperialism was the place granted to law and justice in imperial ideology. On the one hand, Roman law and jurisdiction participated in the construction of Rome's imperium and were one of its tangible manifestations alongside taxes and the military, even though, it must be emphasized, Roman law was never imposed on the populations, on the provincial populations. On the other hand, Roman or pro-Roman discursive and visual communication efforts about the efficiency of the Roman legal system conveyed the ideological message of Rome's superiority in the legal realm vis-à-vis other peoples. Generally speaking, laws, courts, and judicial proceedings represent an aspect or a manifestation of political power. They correspond to the type of power Max Weber describes as Herrschaft, institutionalized legitimacy-conferring power, in contrast to Macht, which stands for raw power, closely associated with physical violence. For the Palestinian rabbis in the 2nd and 3rd centuries CE, Roman law was clearly one of the forms taken by Roman power, and they sometimes explicitly characterized the Roman law court as a place of violence, assimilating the tribunal to the arena of the amphitheater and other places where people were put to death in a violent way. Modern historians and jurists often take for granted that the rabbis prohibited Jews from resorting to foreign law courts, maybe in view of the prohibition in Leviticus 18:3 to follow the practices and statutes of the Egyptians and the Canaanites, which could be extended to Gentiles in general. However, Martin Goodman and Hannah Cotton have noticed that there are few Tannaitic texts explicitly documenting the rejection of non-Jewish courts, and that we have nearly no example of a concrete conflict of jurisdictions in Tannaitic sources. Tannaitic sources are early rabbinic sources from the 2nd and 3rd century CE. The fact is that the reality on the ground differed to a great extent from an ideal of legal separation between Israel and the nations. Admittedly, the scale of Jewish use of non-Jewish courts in Palestine is debated among scholars. But that Jews resorted to non-Jewish courts is shown by the papyrological evidence from Egypt, the documents from the Judean desert, the Babata and Salome Komaise archives, dating to the beginning of the 2nd century CE, as well as indirectly attested in rabbinic literature itself. On the other hand, there must have been local Jewish courts in Palestine during the 2nd and 3rd century CE, even if we are dealing with something the Romans would consider a form of arbitration, which in fact it was. The documents from the Judean desert only refer to the court of the Roman governor, but as Hannah Cotton underlines, and I quote, "It would be absurd to claim that the Roman government took it upon itself to deal with all civil cases in the province of Judea, Syria, Palestina." In any case, however, Jews knew and used Roman legal institutions from early on. According to the scholarly consensus, the first rabbinic compilations, the Mishnah, the Tosefta, the Halachic Midrashim, or biblical commentaries, were edited in the 3rd century CE, probably after the Edict of Caracalla that granted Roman citizenship to most free persons within the empire in 212. So after 212, it would have been all the more foolish to try to prevent Jews, who were now Roman citizens, from turning to a Roman court. Some Jews could have complained to the governor about the behavior of the rabbis, which could have appeared as subversive. This context may explain why there are few Tanaitic texts explicitly documenting the rejection of Roman courts. However, the famous principle of Dina de Malchuta Dina, the law of the kingdom is the law, which is attested in Babylonian rabbinic sources and was popular in medieval Judaism, is absent from the Palestinian rabbinic compilations. So the question arises, how did the Palestinian rabbis consider the fact for Jews who had to settle a dispute between themselves of turning to a non-Jewish court? Did they accept this practice, no matter how reluctantly, or condemn it? Did they follow a general rule or decide on a case-by-case basis, etc.? In this lecture, I shall argue that at the time of the Tanaim, some rabbis at least consider the Roman law courts as places associated with idolatry, and that the rationale behind this position was covenantal. In other terms, these rabbis considered that Israel should be judged by Jewish judges according to the laws given by God, and not by Gentile judges using the laws of the nations, nor, for that matter, by Gentile judges using Jewish law. Before looking at the few sources that document the rabbis' rejection of Roman, or more broadly, non-Jewish courts in the Tanaitic period, I would finally like to emphasize that the rabbinic discourse concerning the laws and the tribunals that should be used by Jews is not only a religious, but also a political discourse, first vis-à-vis the Roman authorities, whose sovereignty was in certain cases challenged, and vis-à-vis fellow Jews, over whom the rabbis attempted to establish their authority and power, a power based on religious legal knowledge. In this case, the political function of the Mosaic Law, to quote the call for papers, could also consist in conferring authority and power to the rabbis. So first, a passage in the Mishnah Gittin 9:8 rejects the interference of non-Jewish legal courts in trials between Jews in matters of divorce, Gittin. The passage states, a bill of divorce given under compulsion, if it is ordered by Israel, an Israelite court, it is valid, but if by the Gentiles, a Gentile court, it is invalid. But it is valid if the Gentiles force the man and say to him, do what the Israelite authorities tell you. This text warrants several comments. First, it implies that there were indeed cases in which Jews got divorced at a non-Jewish court. In the light of the documentation from Egypt and the Judean desert, it is possible to imagine, for example, that at the beginning of the 2nd century CE, there were Jewish women who took the initiative to require the divorce, and in case of conflict, went to non-Jewish courts. Many aspects of marriage law seem to have been fluid in the 2nd century CE. As Hannah Cotton remarks in connection with the documents from the Judean desert, at least until 135, there was no normative, authoritative, and uniform marriage contract which Jews knew that they had to use. She further adds, obviously the Jews who wrote these documents felt free to use the legal instrument that seemed to them most effective. Second, it seems that the issue of marital and family laws was one the rabbis were particularly keen at controlling. And this makes sense because marriage laws are fundamental for determining the status of a person. This was also politically clever, insofar as control over family structures is crucial to achieve control over society as a whole. That marital and family laws mattered a lot to the rabbis is corroborated by another passage found in Tosefta Yevamot 12:13, which deals with chalitza, the procedure to be followed if a man does not want to marry his brother's widow. That comes from Deuteronomy 25. The text asserts that a chalitza performed under compulsion is valid if performed at an Israelite court, but invalid if performed at a Gentile court, except if the Gentiles force the man and say to him, "Do what Rabbi X bids you." The formulation is very close to that of Mishnah Gittin 9:8, except that in the Tosefta, the vague term Israel or the Israelites is replaced by the more explicit Rabbi X. What is at stake is thus rabbinic control, not merely Jewish control. Both the Mishnah text and the passage from the Tosefta are extremely interesting because they simultaneously reject the authority of the Gentile court and accept it if it is meant to force Jews to comply with Jewish, or more precisely, rabbinic, law and legal decisions. Ultimately, then, the Roman legal system may be accepted even in matters of divorce if it is an instrument that serves the rabbinic legal system, if it is in a way subservient to it. The rule formulated in Mishnah Gittin is echoed in the Mechiltad Rabbi Ishmael, a Tannaitic midrash on the book of Exodus from the 3rd century CE. Commenting upon Exodus 21:1, "And these are the ordinances which you, Moses, shall set before them, Israel," the midrash reports the following opinion expressed by Rabbi Eliezer ben Azariah, a Tana from the 2nd generation, active at the end of the 1st century and at the beginning of the 2nd. Rabbi Eliezer ben Azariah says, "Now, whenever the Gentiles were to judge according to the laws of Israel, I might think that their decisions are valid. Scripture says, 'And these are the ordinances which you shall set before them.' You may judge theirs, but they may not judge yours." On the basis of this interpretation, the sages say, a bill of divorce given by force, if by Israel it is valid, if by the Gentiles it is not valid, etc., a quotation from the Mishnah. Now, this text has been analyzed in depth by Natalie Dorman, and I will limit myself to emphasizing 2 points. First, in comparison with the Mishnah, the previous text you had on the screen, Rabbi Eliezer ben Azariah extends and generalizes the prohibition found in Mishnah Gittin. Whereas the Mishnah dealt with a very limited case, a bill of divorce given under compulsion, the statement of Rabbi Eliezer in the Mechilta has far-ranging implications. In theory, it implies that Jews should never be judged by a non-Jewish court. Jewish judges, however, may judge others, a point one could describe as a mimicry of the universal jurisdiction of the Romans within the empire. This passage therefore reflects something much more subversive than the Mishnah. Second, it is important to highlight that it is not the content of the laws involved in the judgment which are at stake here. And I can think of at least 2 ways to understand Rabbi Eliezer's statement. He may be admitting that in some cases, non-Jewish and Jewish laws and sentences converge and therefore look quite similar. Alternatively, he may be saying that in some cases, in civil matters, non-Jewish tribunals follow the laws of the Jews in trials implying Jews, laws that the non-Jewish judges would have considered customs. Whatever the exact scenario contemplated by Rabbi Eliezer, the point he wants to make is that the non-Jewish court is not legitimate to judge members of the people of Israel, even if it were to judge them according to the laws of Israel. As far as the Jews are concerned, the non-Jewish court is simply not legitimate per se. and the rationale behind this stance is covenantal. The last text often quoted in connection with the rabbi's rejection of non-Jewish tribunals is a baraita, that is a tradition going back to the period of the Tanaim but not included in the Mishnah, found in the Babylonian Talmud, Tractate Gittin 88a. It is a saying attributed to Rabbi Tarfon from the first half of the 2nd century CE, quoted in the context of a discussion of Mishnah Gittin 9.8, the Mishnah which we examined previously. Rabbi Tarfon teaches in a way that is reminiscent of Rabbi Eliezer ben Azariah in the Mechilta that in any place where you find Gentile law courts, even though their law is the same as the Israelite law, you must not resort to them, since it says, "And these are the ordinances which you shall set before them." Same biblical verse, Exodus 21:1. Before them and not before Gentiles. Rabbi Tarfon concurs with Rabbi Eliezer ben Azariah in the prohibition of non-Jewish courts in general and not merely in certain matters. Again, Jews are warned not to be misled by the apparent similarity between their laws and the laws of the Gentiles. The reason for the prohibition of the Gentile courts, based on Exodus 21:1, like in the Mechilta, is that Israel has received laws or ordinances that pertain to Jews alone. In other words, Israel has its own legal system which involves God-given laws and judges. And this covenantal rationale is even more explicit in other rabbinic texts. So again, in connection with bills of divorce, we find the following discussion in the Mishnah Tractate Yadayim. A Galilean min, a heretic, said, "I cry out against you, O Pharisees, for in a bill of divorce you write the name of the ruler together with the name of Moses." The Pharisees said, "We cry out against you, O Galilean min, for you write the name of God together with the name of the ruler on the same page, and in addition you write the name of the ruler on top and the name of God below. As it is written, 'And Pharaoh said, Who is the Lord that I should hearken unto his voice to let Israel go?' Exodus 5:2. But when he was smitten, what did he say? 'The Lord is righteous.' Exodus 9:27. Now this text implies that in order to be valid, and probably in the eyes of the Roman authorities, a bill of divorce written by Jews had to include a reference to the ruler, the moshel, in charge at the time the divorce was pronounced, either the governor or more probably the emperor. And the document may have been dated either in reference to the emperor's function or maybe in reference to the two councils, one of them being the emperor at the time of the rabbis. So the name of the emperor would appear on the Jewish bill of divorce alongside a reference to the law of Moses. And this text prompts an additional comment, as the emperor's place within the Roman legal system became increasingly prominent with the development of rescripts, that is, direct imperial responses to cases that were brought to the emperor's attention. The parallel between him and Moses became all the more meaningful, and for Jews living within the Roman Empire, raised the question, who is the true lawgiver? And what is the true law? That of Moses or that of the emperor? In the end, the Galilean min accuses the Pharisees of putting Moses and the emperor, the moshel, the ruler, on the same footing. The answer of the Pharisees consists in a counterattack. They accuse the min of writing the name of the emperor and the name of God himself on the same document. Not even side by side, but the former above the latter, as if the Roman emperor was above God. The bill of divorce then thus becomes a symbolic display of the hierarchy existing between two legal systems and two types of authority. Through the voice of the Pharisees, the Mishnah states that the highest and actually the only true authority and source of law or sovereignty is God, not the emperor, and that reversing this hierarchy is impious. Now, another Tanaitic text goes one step further by explicitly associating Gentile courts and judges with idolatry. This text comes from the Midrash Tanaim on Deuteronomy, a work that is dated to the Tannaitic period, but is not without problems, since it has been reconstructed by its modern editor, David Hoffman, from several sources. The passage quoted here, however, is identified by Hoffman as stemming from the original Mechilta Deuteronomy attributed to the school of Rabbi Ishmael. Drawing upon Deuteronomy 16:18, you shall appoint judges and officers in all your towns which the Lord your God gives you, according to your tribes, and they shall judge the people with righteous judgment. The Midrash states, concerning what it says, you shall appoint, this teaches that judges have been given only to Israel. And this is said to teach you that whoever goes to a judge among the nations, among the ummot of the world, it is as if he was practicing idolatry, avodah zarah. Indeed, Scripture says, you shall appoint judges and officers. And afterwards it is written, you shall not pervert justice. Justice and only justice you shall follow. You shall not plant any tree as an Asherah beside the altar of the Lord your God, which you shall make. Not only that, but whoever leaves aside the judges of Israel and goes to the judges of the nations of the world, he denies the Holy One, blessed be he, from the start. As it is said, for their rock is not as our rock, that our enemies be judges. And here is a quotation not from Deuteronomy 16, but from Deuteronomy 32:31. Why? Because their laws are not good. The affirmation that whoever goes to a judge among the nations of the world, it is as if he was practicing idolatry, is based on the juxtaposition in Deuteronomy 16 of verses dealing with the appointment of judges and the exercise of justice within Israel, and a verse pertaining to the prohibition of idolatry, symbolized by the Asherah. Whereas in chapter 16 of Deuteronomy, these laws simply follow each other with no particular connection implied, the Midrash sees their juxtaposition as meaningful according to an exegetical technique frequently attested in Rabbinic Midrash. The redactors of the Midrash then try to develop their point and to provide additional evidence for it by affirming that the fact of leaving aside the judges of Israel and going instead to the judges of the nations is tantamount to denying the God of Israel. The justification for such a statement lies in another verse from Deuteronomy 32:31, which reads, Ki lo ketsurenu tsuram voiveinu plilim, a somewhat ambiguous text. It is generally translated as follows, for their rock is not as our rock, even our enemies themselves being judges. That's the King James translation. Or even our enemies testify to it. However, it makes more sense to translate the biblical text as follows. For their rock is not as our rock, however, our enemies are judges, implying in Israel's present situation, which is one of oppression. Now, it seems that the Midrash understands the verse in yet a third way, as meaning, for their rock is not as our rock, that our enemies be judges over us, as I have translated here. In other terms, because their rock, which here probably means their gods, is not as our rock, the God of Israel, our enemies can in no way judge us. They have no right to be appointed as judges upon us. Thus, the fact for a Jew to go to a non-Jewish judge means that he or she is breaking the covenant and rejecting not only the judges of Israel, but ultimately God himself, the most perfect judge. The Midrash, in its theoretical radicality, does not consider the possibility that no Jewish court be available or that it be powerless to enforce its decisions. Instead of offering a way to neutralize idolatry, as other rabbinic texts do in other contexts, the Midrash reaffirms or strengthens the idolatrous dimension of the act of resorting to a non-Jewish court. And let us now go back for a moment to the Baraita found in the Babylonian Talmud, which merely stated, in any place where you find Gentile law courts, even though their law is the same as the Israelite law, you must not resort to them, since it says, and these are the ordinances which you shall set before them and not before Gentiles. So admittedly, in this text, in the Babylonian Talmud, no reference to idolatry per se is found. However, the rationale behind Rabbi Tarfon's statement is similar to that of the Midrash Tanaim on Deuteronomy 16:18. In both cases, the issue at stake is the covenant between God and Israel. Israel's laws are not merely laws like those of the nations. They are God-ordained, divinely inspired, and good, whereas those of the nations are not good and, we may guess, not given by God, even when they look like the laws of Israel. Jews must stick to Israel's laws and judges because they are part of the covenant between God and Israel. Conversely, participation in the legal systems of the nations, be they Roman or Greek, implies the recognition of the authority of a different rock. Here I go back to Midrash Tanaim, and a breach of the covenant between Israel and God. It seems that from this perspective, every legal system has a religious backing. Just as Jewish judges and laws have a divine foundation in the God of Israel, similarly, the judges and laws of the nations have a religious foundation in their gods, in their rock. The link between the tradition in Midrash Tanaim and the Babylonian Talmud was clearly perceived by Rashi, the great medieval commentator, who writes in his commentary of Exodus 21:1, the passage quoted in the Babylonian Talmud, "Before them, but not before Gentiles. Even if you know that they judge a certain law similarly to the laws of Israel, do not bring it to their courts, for one who brings Jewish lawsuits before Gentiles profanes the divine name and honors the name of idols to give them importance, as it is said, for not like our rock is their rock, that our enemies be judges over us." Again, Deuteronomy 32:31. When we let our enemies judge us, this is a testimony to the value of the fear of them, which actually means to the value of the cult of their idols. Rashi combines the two traditions and makes the underlying rationale behind the rabbinic text even clearer by stating explicitly that to go to a Gentile judge is equivalent to recognizing the value of the gods of the Gentiles. In short, it seems that from the perspective of some rabbis at least, there was a connection between non-Jewish courts and idolatry, which was not so much a problem of concrete idolatrous objects or practices at the law court itself, as a problem of covenantal regime. Insofar as law lies at the heart of the covenant between God and Israel, it is the least neutral space one could think of. This perspective, which relies on the covenantal thinking inherited from the Bible, seems to have been partly overcome by a more accommodationist view, permitting Jews to have their disputes settled in non-Jewish courts in some cases, as we saw actually in the passage from Mishnah Gittin with which we started. It is possible that this evolution had to do with the emergence of the patriarchate and the improvement of the relationship between the rabbis and the Roman authorities during the 3rd century CE. It may also be explained not so much as a chronological, historical development, but as a reflection of the diversity of opinions expressed in rabbinic literature. Be that as it may, it is striking that the emphasis on the connection between the judges, or rabbinic authorities, and God, reflected in other Palestinian rabbinic texts as well, one, served to strengthen the authority of the rabbis over fellow Jews, and second, was deeply countercultural in the context of the Roman Empire in the 3rd century, at a time when Roman law was fully developing as a non-religious law, as a technical field in itself. To conclude, the rabbinic stance toward non-Jewish and more specifically Roman courts was ambivalent and complex. On the one hand, a clear rejection of the Roman legal system, as implied by the statements of Rabbi Eliezer or Rabbi Tarfon, remained rare, and most Palestinian rabbis seem to have been willing to accommodate to a certain extent, at least at the practical level. The fact that the rabbis allowed the intervention of non-Jewish legal authorities in certain cases, and notably, it must be emphasized when these authorities help to establish the authority of the rabbis themselves, led the fact that the rabbis allowed the intervention of non-Jewish legal authorities led to a neutralization of the idolatrous dimension of the Gentile law courts. And in an article on the Midrash Sifra, Bet Berkowitz has emphasized the importance of the strategy of neutralization of idolatry to the institutionalization of rabbinic authority. But she does not address the issue of law courts. Now, as in the legal realm, it seems to me to have worked both ways. So on the one hand, the rabbis' pragmatic compromises with the Roman legal system certainly contributed to the institutionalization of their authority, because rabbis mediated between Jews and the Roman authorities. On the other hand, however, as we have seen in this lecture, some rabbis emphasized the idolatrous dimension of non-Jewish courts and conversely, the godly dimension of Jewish and especially rabbinic courts and legal teachings, thereby rejecting the disconnection between law and religion. And this refusal to disconnect law and religion, and this refusal to see legal systems as something neutral, separated from the religious sphere, was probably crucial too, in the end, to the establishment of rabbinic authority within Jewish communities. By pointing at the covenantal dimension of laws and courts, the rabbis could claim to be continuing the biblical tradition, and this positioning helped them to acquire for themselves and for the legal tradition they elaborated an authority and a legitimacy which they could claim owed nothing to Roman power, but everything to God. Thank you.